this case, the defendant, known only by made-up initials to protect the privacy of his victims, was convicted of a serious sexual offence against his ex-wife. He maintained his innocence and 15 years later claimed that new evidence had emerged which would exonerate him. Normally, once appeals have concluded, that's the end of a legal matter. However, the criminal process does provide the Supreme Court a discretion to reopen a criminal matter where new evidence has emerged. Discretionary decisions are in some ways rather odd. With most legal decisions, there are rules or elements, and if you prove those, you're entitled to your remedy. Discretions, however, are the personal call of the decision maker. The decision maker is asked to use their personal judgment. In this case, the judge used their personal judgment to decide whether to reopen the case. However, discretion often operates in conjunction with rules. So, for instance, in this case, the discretion only existed if it appeared that there is a doubt or question as to the convicted person's guilt, as to any mitigating circumstances in the case, or as to any part of the evidence in the case. And then there's other guidance. For instance, the provision says that the judge might refuse an application if the judge is not satisfied that there are special facts or special circumstances that justify the taking of further action. Professor Ronald Dworkin, a key figure in jurisprudence, once explained discretion this way. Discretion, like the hole in a donut, does not exist except as an area left open by a surrounding belt of restriction. It is therefore a relative concept. It always makes sense to ask, discretion under which standards, or discretion under which authority? In other words, you start with the rules which establish a particular discretion, and then whatever's left over is the area of actual discretion, where the judge makes decisions without following specific rules. In this case, the judge had used their discretion and decided not to reopen GAR's case. GAR appealed, and the appeal court had to decide whether the discretion had been used properly. Justice of Appeal McCallum quoted Professor Dworkin and found that the discretionary space left to the judge was ample to allow that judge to decide not to reopen the case. Another example of concepts of jurisprudence being directly applied in our highest courts.